Attention, please. While the Honorable Chief Justice of the Philippines and the Associate Justices of the Supreme Court of the Philippines are now entering the virtual session hall. Hear ye, hear ye, hear ye, all persons having business before the Honorable Supreme Court of the Philippines shall give their attention, for the court is now in session.
All the cases.
Your Honors, good afternoon. This is a continuation of the oral arguments on the 37 consolidated petitions assailing the constitutionality of Republic Act Number 11479 or the Anti-Terrorism Act of 2020.
Appearances.
May we request the 7 presenting lawyers for the petitioners, the counsels for the respondents, and the amicus curiae make the respective appearances.
Your Honors, Edsel Lagman, same appearance in GR number 252579. Thank you, Your Honors.
Your Honors, Neri Colmenares, for the petitioners, Your Honor, in GR number 252903. Thank you, Your Honors.
Good afternoon, Your Honors. Attorney Theodore Te for the Free Legal Assistance Group, together with Attorneys Camille Parpan and Michael De Castro, the same appearance for petitioners in GR number 252741.
Good afternoon, Your Honors. Evelyn Ursua, respectfully appearing for the petitioners in GR number 252747.
Good afternoon, Your Honors. Assalamualaikum. Pitching in for Attorney Algamar Latif, I'm Attorney Bantuas Lokman, respectfully appearing as counsel for GR number 252759.
Your Honors, good afternoon. I am Jose Anselmo I. Cadiz, respectfully appearing for the Integrated Bar of the Philippines and its Board of Governors in GR 253124, Your Honors. Ready, Your Honors.
Lala.
Good afternoon, Your Honors. Attorney Darwin Angeles, respectfully appearing for petitioners in GR number 252736. Thank you, Your Honors.
Lala. That's it.
Response.
We recognize the presence of retired Justice Francis Hardilesa as amicus curiae.
Yes, Your Honor. Good afternoon.
So where is the Solicitor General? Because this is a continuation of the interpellation of the Solicitor General by the members of the court. Mr. Solicitor General, we cannot hear you.
Okay. Yes. 1, 2, 3, test.
The audio of the OSG is not clear. Please adjust. Thank you.
One, two, three. Testing, testing, 1, 2, 3.
If we can adjust the volume, please.
One, two, three. 1, 2, 3. Clear.
The audio is muffled. OSG, please adjust the audio.
Test, 1, 2, 3.
We cannot hear the Solicitor General.
Solicitor General Calida, baka po pwedeng ibaba natin ng onti yung microphone. Masyado po atang mataas din.
Please adjust the microphone of the Solgen.
One, two, three. One, two, three.
Di pa rin marinig.
Is it clear?
It is still muffled. OSG, please adjust.
One, two, three. One, two, three. Is it clear?
Still muffled. Do you have another microphone?
One, test. 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 Microphone test. 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 One, two, three. Is it clear?
Still muffled po.
Test. One, two, three. Test. One, two, three.
That's better po, but if you can adjust the volume a little bit more.
Okay. Test. One, two, three. Test. One, two, three.
There you go.
Okay na?
Okay. Sorry for that, Your Honors.
You may proceed, Solgen.
Thank you, Your Honors. For the respondents, Your Honors, are the following. Assistant Solicitor General Marisa de la Cruz Galandines, Assistant Solicitor General Bernard Hernandez, Assistant Solicitor General Rex Bernardo Pascual, Assistant Solicitor General Raymond Rigodon, Assistant Solicitor General Diana Castañeda de Vera, State Solicitor 2 Eduardo Poquis Jr., and Assistant Solicitor 2 Jose Dominic Clavano IV. Thank you, Your Honors.
Ready, Mr. Solicitor General, for the interpellation of the other justices?
Chief Justice, ready, Your Honor.
Ready? Justice Jolo Lopez will conduct his interpellation. Justice Jolo, please proceed.
Can you hear me? Do you have ASG Rigodon? Can I call him first to the podium? Yes, Your Honor. To answer my questions? Then I'll call you later on, ASG Galandines.
afternoon, Your Honor.
Good afternoon, ASG Rigodon. You must be very proud of your position as ASG. Some of the best minds in court came from your ranks. We have our very own Chief Justice, Alex Tresmundo, and the very lovely Justice Ami Javier. You realize that, ASG Rigodon?
Yes, Your Honor.
So let me proceed to my questions now, ASG Rigodon. Now, you mentioned in the last interpellation that under Section 4 of the ATA law, there are three requisites. First, there must be an act. Second, there must be intent. And third, there must be purpose. Is this correct, ASG?
Yes, Your Honor.
Now, intent under Section 4 of the ATA law, is this the same as criminal intent as we know under the revised penal code and in all cases of mala in se?
Yes, Your Honor.
The same? Let me define to you what is criminal intent, which has to be proved also as part of the element of the crime. Criminal intent is the use of specific means to effectuate a particular purpose or result. So when you try to kill a person, you use a specific means. That is, you use knife to stab the person to death, and that is the criminal intent. Is this the same as intent as what you mentioned as required under the ATA law?
Yes, Your Honor.
So granting that you are correct, let me go to the third element, which is purpose. The purpose under the ATA law is to intimidate the general public, to create an atmosphere of fear, to influence by intimidation the government, to destroy political, social, and economic structures of the government, and lastly, to create a public emergency. Now, my question is, if this purpose, like creating in the minds of people some kind of fear, continues to exist and persist, will that make the crime a continuing crime?
It will depend, Your Honor, on the...
I cannot hear you. Can you speak? Can we check on the audio?
It will depend, Your Honor, on the intention of the person who committed the crime, Your Honor, because...
But you said the intent is different for purpose. The intent, the act is intended to cause injury or destruction of property. And purpose is a altogether different matter from intent. The purpose is to create, let's say, in the exam, I'll give you an example. If the purpose is to create a public emergency, and that public emergency continues to exist and persist, will that make the crime a continuing crime?
Again, Your Honor, it depends because if the commission of the act is a one-time act, Your Honor, let's say Pedro and Juan conspired to bomb a certain building, and after committing that act, they have no other intention of committing other acts.
Series of acts.
Yes, Your Honor. But if the purpose of their conspiracy is to intimidate a certain segment of the population through the use of violence, the commission of an act that destroyed a property belonging to that segment of the population will not be considered as having consummated the crime but can be considered as a continuing as part of a series of acts and therefore a continuing crime, Your Honor.
So meaning you don't have to, is there any problem with the audio? We cannot hear you loud and clear, ASG.
Mic test, Your Honor. 1, 2, 3.
ASG Rigodon, can we adjust the height of the microphone? Thank you.
Is the audio better, Your Honor? Now?
So you're saying it depends, but when do you determine if there is a purpose? Is it the time of the commission of the act, or there is already a purpose which is supposed to be achieved?
If the reason for committing the act of terrorism is deemed by that person or organization as achieved after the completion of a terrorist act, then it is not a continuing crime. But if the commission of that terrorist act is part of a series of attacks to intimidate or so fear on the population, then it can be considered as a continuing crime, Your Honor.
So if the purpose continues to persist, as in my example, it continues to strike fear in the minds of the people, that would make it a continuing crime, and therefore there is no need for any court to issue any warrant, and for that matter, not for even for ATC to issue any written order to put into a custody a person suspected of committing any of these crimes. Are you saying that, ASG?
Yes, Your Honor. If we are going to compare by analogy the ruling in Umil versus Ramos, that the commission of one act in relation to rebellion does not consummate the crime of rebellion, but is a continuing crime, because the ultimate goal is to overthrow the government, and that purpose is not accomplishing by continuing committing one act of rebellion, Your Honor.
So you're comparing it to rebellion by citing the case of Umil versus Ramos. So if your explanation is correct, in that case, if the purpose continues to persist and continues to exist, that will make the crime a continuing crime.
Yes,
correct?
Yes, sir.
Now, we go to section 29. Now, you also mentioned during the last interpellation that ATC cannot issue a warrant of arrest because in the first place, only courts can issue warrant of arrest. Is this correct, ASG?
If you may I refer that question to ASG Calandino?
So it was not you.
Yes,
So, sige, you can call in ASG Calandines.
Good afternoon, Your Honor.
No, so it was you who mentioned during the last interpellation that ATC has no power to issue any warrant precisely because the ATC is not a court of law or court of justice that can issue warrant of arrest. Is this correct, Mr. ASG Galandinas?
That is correct, Your Honor.
Now, let me refer you to section 29. Now, in section 29, ATC may authorize the law enforcement agent or any military personnel in writing to take into custody a person suspected of any of the crimes mentioned from section 4 to section 12 of the ATA law. So I have two questions regarding this. Now, first is the use of suspected. Does this mean the quantum of evidence necessary to put a person in custody is only based on suspicion and not even on probable cause?
Probable
as required under Rule 113 on warrantless arrest. And number two, is it not clear from the wording of the law that the ATC may authorize in writing, meaning it can issue an order to take into custody a person suspected of committing this crime? Is this not the same as issuing a warrant of arrest, but coined in a different language to take a person suspected into custody?
Your Honor, Section 29 is detention by virtue of a valid warrantless arrest. Probable, by virtue of a valid warrantless arrest. The APC.
Based on probable cause.
Yes, Your Honor.
Probable cause is required under Rule 113, is it not?
Yes, Your Honor. Probable cause as probable cause for the arresting law enforcement agent or the military personnel, Your Honor.
Okay.
And this and probable cause for the arresting officer is the probable cause defined and initiated by this court in the case of Pestillos versus Generoso and People of the Philippines. In the 2014 case of Pestillos, probable cause for the arresting officer has been defined as that reasonable belief that a crime, suspicion coupled with reasonable suspicion coupled with good faith. An arresting officer should base his determination of probable cause on his own personal knowledge of facts and circumstances that the person sought to be arrested has in fact committed the crime. This is different, Your Honor, we submit, from the probable cause by the prosecutor and probable cause.
Yes, there is no quarrel with that. There's no disagreement with that, ASG. But my question is that the law itself says they can put into custody a person suspected only of committing any of these crimes, and it is in written order. Is this not the same as saying the ATC can issue a warrant of arrest, but in this case, it is to issue a written order to put a person suspected under the custody of law?
Your Honor, we submit that the written order is for the continued detention of the suspect who was arrested following a valid warrantless arrest. It is not a written order.
So is this, yes, so please finish, sorry, ASG.
Your Honor, this is a written order for the continuous
For
detention.
the continued detention.
Your Honor.
Is this your interpretation or the intent of the lawmakers who passed the law itself?
Yes, Your Honor.
Because I was just wondering why they used the word to put into custody a person suspected of any of these crimes. Have you taken a look into the proceedings of Congressman, why they use these specific words? Because the words, when they are clear by themselves, need no interpretation by the OSG, by this court. We go into the intent of the lawmakers. Is it not, ASG Galindez?
Yes, Your Honor.
Galindez, I'm sorry.
Yes, Your Honor. And we did look into the intent, and it was very clear from the interpellation of Senator Lacson, the principal author of this bill, that the intention of the law was for the ATC to issue a written order for the continued detention and not for the issuance of an arrest order, Your Honor.
So thank you for that clarification, ASG Galandines.
Thank you.
Now we go to the extra period of detention.
Yes.
Now, under the Constitution, particularly Article 7, Section 18 of the Constitution, says that the period of detention without filing any charges, the maximum period is 3 days, and only on two conditions. Only on these two conditions obtaining. Number one, there is a suspension of the privilege of the writ of habeas corpus. And second, only in cases of rebellion or invasion when public safety requires it. Are you aware of that, ASG?
Yes, Your Honor. We are aware of...
So now my question is, what makes you think that under ordinary times, like what we are having right now, when there is no suspension of the privilege, you can detain a person to as many as 24 days when the Constitution limited to 3 days only at maximum during suspension of the privilege of the writ of habeas corpus.
Your Honor, we submit that Section 18, Article 7 of the 1987 Constitution contemplates extraordinary situation where the privilege of the writ of habeas corpus has been suspended. The Anti-Terror Act of 2020 does not contemplate such extraordinary circumstance. Thus, there is no ground to apply the 3-day limitation found under Section 18, Article 7 of the 1987 Constitution, Your Honor.
But looking into the spirit of the law, can you not see that what you were saying, under extraordinary circumstances, the limitation, the maximum is only 3 days. And yet, under ordinary times, like what we're having right now, we are under ordinary times. There is no emergency, no anything, no rebellion, no anything. And yet, the maximum period of detention is 24 days.
Correct, Your Honor. Terrorism is a crime. Terrorism is different from just an ordinary crime, Your Honor. And that is
No, I'm talking about the suspension of the privilege.
Yes, Your Honor.
We are now not under any situation where there is a suspension of the privilege. We are under ordinary times. And now you're talking about rebellion and invasion. What makes you think that violation of ATA law is even higher than rebellion or invasion? When rebellion or invasion, the life of the nation itself is at risk or at stake. So can you see the comparison, 24 days under the ordinary law, and yet the Constitution limits it to 3 days detention?
Your Honor, if we were to look at the spirit and study the spirit behind Section 18 of Article 7 of the Constitution, Your Honor, this came about because of fear that martial law will again be proclaimed by the sitting president. This was actually an answer, this 1987 Constitution was actually an answer to the fear brought about by the previous government, the government prior to the presidency of President Corazon Cojuangco Aquino, Your Honor.
So are you saying that the present Constitution may not be, how do you say it, sufficient because it was intended to meet the exigencies of martial law during the time of President Marcos? So it's not conducive anymore. We have to change the Constitution.
Not that we have to change the Constitution, Your Honor, but it's just that Congress, in its wisdom, provided for a different period in cases of terrorism. Terrorism has evolved from 1987 to the present, Your Honor.
Well, anyway, you look again into the congressional proceedings or the proceedings of the constitutional commissioners who drafted our 1987 Constitution. In fact, I quoted it during the last interpretation. So try to look into it, ASG Galandines. Now we go to section 25 on designation.
Yes, Your Honor.
Now you mentioned again that designation is only for purposes of applying for a freeze order and nothing more. Is this correct? Were you the one who mentioned it during the last interpellation? That designation is merely for purposes of applying for a freeze order from ATC for the first 20 days and for its extension with the Court of Appeals.
That is correct, Your Honor. The assets of the designated individual, group of persons, organization, or association shall be subject to the authority of the Anti-Money Laundering Act pursuant to Section 11 of Republic Act 10168. Also,
yes,
this is without prejudice to the filing of a subsequent case for prescription, Your Honor.
or prescription. Now, let me go back. During my time when I was Associate Justice of the Court of Appeals, we had cases of AMLA cases against perhaps terrorists. There was never any kind of designation. You can file it with the Court of Appeals and get a freeze order without having to designate anybody or any organization as terrorist. Would you think it is a surplusage? And going back to my next question, is designation by itself a penalty? Because in the eyes of the law, you are already designated a terrorist. In fact, in the eyes of your family, of your friends, your relatives, your neighbors, and in fact of the entire country, no. And they will know, and in their eyes, they will know that you are already a designated terrorist. So do you think this is not a surplusage that need not be put into the law?
No, Your Honor. Designation is executive and administrative function of the ATC. It is a preventive measure, Your Honor. The process of designation does not amount to indictment or conviction, Your Honor. No penalty is automatic.
It's not amounting to declaration, but you are designating somebody as a terrorist.
Yes, Your Honor. No penalty is automatically attached to the performance of such executive and administrative.
But is designation not by itself a penalty when you are designated as a terrorist? Would you like to be designated as a terrorist?
No, Your Honor.
No, so no, there is a distinction, and I would like to ask you under Section 25 on designation by the ATC, it refers to terrorist individual, group of persons, associations, or organization. Is this correct?
That is correct.
Now, with regard to proscription, it does not refer to any individual. It refers only to group of persons, associations, or organization. Why the distinction made in the law for designation and proscription?
Your Honor, designation is an administrative function of the ATC. Proscription
is judicial.
Is judicial in nature, Your Honor.
But why do you have to make a distinction when you can go immediately to the court where due process is properly observed and ask for a prescription? Why do you have to go to ATC as an administrative agency and get a designation? And what is the difference between designation of terrorist individual while proscription cannot proscribe an individual terrorist as a terrorist? Did you see the difference? Under designation, there is individual, but under proscription, there is no such thing for individual, only for group of persons in general.
Correct, Your Honor. Any group of under Section 26.
But why is this so? Why is this so? Why not allow proscription also for terrorist individual? Why is it not allowed?
Your Honor, we submit that this is the difference between Section 26. In Section...
No, I'm referring to the groups.
Yes, Your Honor.
Under proscription, hindi pwede individual eh. But designation, it allows individuals to be designated as terrorists, but not under proscription.
Correct, Your Honor. Because in proscription, Your Honor, the individuals are not yet known.
In proscription, the individual is not yet known, only the organization.
Organization or association which commits any of the acts.
Is this your interpretation or the intent of the framers of the law?
This is our...
Your interpretation.
We submit, Your Honor, that this is the correct interpretation.
This is the correct interpretation made by the OSG.
Yes, Your Honor.
Okay. Now, Now, on matter of the listing, I asked this before during my interpellation with the petitioners' counsel. The listing was not provided in the law itself, but it was provided under the implementing rules and regulation by the DOJ. And I asked this of Congressman Lagman, and his response was because it was not included in the law, so his own interpretation tells him that the listing is null and void because there is no such animal or such thing in the law itself. Were you able to get it?
Yes, Your Honor. The request for the listing is provided for under the implementing rules and regulations, particularly Rule 6.9, Your Honor.
But not in the law itself.
Yes, Your Honor.
So can you implement something which cannot be found in the law?
Yes, Your Honor, by virtue of valid delegation, Your Honor.
But how can it be valid when there is no law itself? It would amount to a, according to Justice Laurel, running amok, a delegation running amok. I don't know if that is the words used, but let me give you some idea on administrative law that because of the expertise of agencies,
yes, correct,
they can fill in some gaps. Do you think this is one of the gaps that the implementing rules and regulation can fill in because it was not provided for in the law?
We submit, Your Honor, that Section 54 is a valid, Section 54 of the law is a valid exercise of the power of subordinate legislation since it passes both the completeness test and the sufficient standard test, Your Honor.
But there is nothing in the law which says about the listing.
We submit, Your
Honor. What standard are you saying of? What standard are you telling me, or what completeness test you are telling me when there is nothing about the listing at all?
Your Honor, we submit that the law must be read in whole, and under Section 46, paragraph N, it provides that, if I may quote paragraph N, Your Honor, it gives the, it provides that it may investigate motu proprio upon complaint any report of abuse, malicious application, or proper implementation by any person of the provisions of the Anti-Terror Act of 2020, Your Honor.
So in other words, the listing may be appropriate
yes,
as a recourse by individual wrongfully designated by ATC. No, no, let me ask you if ATC, is it an administrative agency?
Yes, Your Honor. We submit that it is an administrative agency, Your Honor.
Under the office of the President, or is it an independent administrative agency, although majority of those who make up the administrative agency are cabinet ministers or are cabinet secretaries? Is it an independent administrative agency? And where do you appeal if you do not agree with the designation made by the ATC or for any matters decided upon by the ATC? If you do not agree, where do you go?
We submit, Your Honor, that if should the parties disagree with the resolution of the ATC, they could elevate the matter to the office of the President, Your Honor.
Office of the President? Are you sure of that?
That is our position, Your Honor.
You go to the office of the President and involve the President in matters of involving terrorist acts of terrorism?
Acts of the ATC, Your Honor. Should there be a disagreement as to the results of the actions of the ATC, you could elevate the matter to the office of the President, and should the individual question the position, the resolution issued by the office of the President, then that individual can elevate the matter to the Court of Appeals, Your Honor, from the Office of the President.
So is it from the Court of Appeals? Now, let me quote to you. I found out in one case, in Galicta versus Aquino. This is February 28, 2012 case. The court, meaning the Supreme Court, dismissed certiorari and prohibition against members of the ATC. This was under the Human Security Act, because they do not exercise judicial or quasi-judicial functions. Do you agree with this, that they cannot go to court because they do not exercise judicial and quasi-judicial functions?
The ATC does not exercise judicial or quasi-judicial functions, Your Honor. Yes, we agree.
So it cannot be, you cannot go to court by petition under Rule 65.
The matter must be elevated first to the Office of the President.
First, Office of the President, where do you go?
Your Honor, I'm sorry, Your Honor, what was the...
After Office of the President, where do you go? The Court of Appeals right away.
You go to the Court of Appeals.
Under what rule?
Under Rule 40...
43?
Rule 43. Yes, Your Honor.
Try to look into that again. ASG Galandines. Now, on planning, attempt, conspiracy, acts of proposal, inciting to committing acts of terrorism. What is the distinction between proposal and inciting? Is the same distinction given under the revised penal code? When you incite others to commit acts of terrorism, it's like proposing it for the others to commit acts of terrorism. Is one the same as the other, or is there any difference with it? Because the rules is not clear, but under the revised penal code, it is clear.
Your Honor, under the Anti-Terror Act of 2020, there is a difference between Section 8 and Section 9. But, Your Honor, can I refer for further discussion on this matter?
Well, anyway, I'm about to finish. My time is up, so we cannot. So since you are already there, might as well wrap up. I have only one or two questions left. ASG Galandines, I'm sorry to bother you so much, but the FATF, I heard that one of the positions of the Office of the Solicitor General, because this is in compliance with the requirement of FATF. What is a FATF?
Your Honor, the question is, what is?
FATF.
FATF is Financial Action Task Force, Your Honor.
So this is an international organization under the United Nations.
Yes, correct.
Would you know if we are member? Because from what I heard, we are not even member of it.
Your Honor,
Well, anyway,
we're a member of the FATF, Your Honor.
we are.
Yes,
From
sir.
your knowledge, because I have been told that we are not even a member of AFTF, although there is an association under it, from which we are also an associate member. So I suppose pasa-pasa lang yan. But we are not officially, from my knowledge, an official member of the AFTF.
Your Honor, we are a member of the Asia Pacific Group.
Asia Pacific Group, but not of AFTF, because the AFATF came out with about, I was reading on it, it has around 49 recommendations. I don't know if we have complied everything. Now, if we are to comply everything, I don't know if we have, if we are really to comply with all these recommendations and how many of these we have already complied with. But anyway, please take a look on it. I have no further questions. I would like to thank the CJ and my other justices for giving me this chance to do the interpellation. And thank you, ASG Galandines, for patiently answering my questions.
Thank you.
Good day to you all.
Good day to you as
Thank
well.
you, Chief.
Thank you, Justice Yolo. May we ask Justice Ricky Rosario to proceed with his interpretation?
Hello. May I request also ASG Galandines
Good afternoon.
let's remain in the podium, okay? How are you today, ASG Marisa Galandines?
I am fine, thank you, Your Honor.
Galandines is your maiden name? De la Cruz, I'm sorry.
Yes, Your Honor.
Okay.
This is my, yes, Your Honor.
If I may ask, of course, my preliminary questions would have no bearing to my questions proper, no, in the interpellation. But how long have you been working in the Soldiers office, Marisa?
Your Honor, I have been here since January of 1992, Your Honor.
As ASG?
As ASG since March of 2004, Your Honor.
So you got your promotion in 2004, no, as
Yes,
ASG?
Yes, Your Honor.
Okay. This is your first time to appear before the Supreme Court and Bank? Not really.
First time to be interpellated, Your Honor.
Okay. Anyway, I hope Attorney Marisa, ASG Galandines, by this time you were already able to recharge yourself after going through a prolonged and extensive interpellation, or shall we say grilling during the last session for the oral arguments.
Yes, sir.
Okay?
Thank you, Your
Okay,
Honor.
okay ka na, ha? Now, I'm about to start with my interpellation, but if in the course of my questioning ASG Galandines, you would feel or realize that the questions being propounded or the question being asked is not really covered by your assigned topic, then feel free to call on your colleagues, the lawyer who is in a better position to respond to my questions. Is that okay with you, ASG?
Yes, Your Honor. Thank you.
You are the most senior in the panel of, the Soldier lawyers who are present here today to take up the charges for the government as far as this issue is, concerned.
For today's hearing, yes, Your Honor.
Okay. This is my first question. In his opening statement, the Solicitor General pointed out that the petitions at bar should be dismissed outright on the ground that petitioners lacked the personality to bring the instant suits.
Yes, Your Honor.
The Honorable Solgen Kalida based his argument on the ruling of this court in the case of Southern Hemisphere versus ATC. I don't know if you are familiar with that case, where the court held that more important, there are other parties not before the court with direct and specific interest in the questions being raised. Of recent development is the filing of the first case for prescription under Section 17 of RA 9372 by the Department of Justice before the Basilan RTC against the Abu Sayyaf Group. petitioner organizations do not in the least allege any link to the Abu Sayyaf group. According to Solgen Kalida, some cases are already pending before the trial courts involving the Anti-Terror Act. Aside from the case of Itas Junior Ramos and Jaffer Gurong, tama ba yan?
That is correct.
4 criminal cases have been filed in Holong against some individuals for alleged violation of Sections 4A and 4D of the Anti-Terror Act. Solgen Kalida insists that the proper party to bring suit against the Anti-Terror Act should be the accused in those cases. As for the meantime, they and they alone stand to be adversely affected by its enforcement, much unlike the present petitioners, the group of Attorney Jokno et al. However, it is noted that the accused in those cases would be affected only insofar as specific provisions of the ATA are concerned, or the ones they allegedly have violated. Still following me? Okay, huh? Turn. Okay. Petitioners, on the other hand, are questioning practically all aspects of the said law. Thus, strictly speaking, the accused in those cases shall only be entitled to question the particular provisions that would have direct impact on their cases, and not the rest of the statute. Thus, also, insofar as the other provisions of the statute go, there is nobody as of yet who is directly affected by it. Okay? Now, in this scenario, ASG, can it be said that the petitioners might, after all, have the right to question their constitutionality on the ground of transcendental importance? You may now.
We submit, Your Honor, that petitioners have no legal standing to sue. Their supposed legal interests are not actual and material, nor direct and immediate. They did not allege any injury, but merely speculate on future circumstances which they considered. They merely allege future circumstances. It bears to stress that the generalized interests do not constitute locus standi, Your Honor. Evidence of a direct and personal interest must always be established. This has been held even in the early case of People versus Vera. The person who impugns the validity of a statute must have a personal and substantial interest in the case that he has sustained or will sustain direct injury as a result of the law, Your Honor.
That is important, the standing.
Yes, we submit, yes, Your Honor.
Okay, now go to my next question, ATA. Section 29 of the ATA provides for the detention of a person suspected of committing any of the acts defined and penalized under sections 4, 5, 6, 7, 8, 9, 10, 11, and 12 thereof without a judicial warrant of arrest. Is this covered by your topic, assigned topic?
Yes, Your Honor.
Rather,
covered by my assigned topic, Your Honor.
Okay, I will continue.
Yes, Your Honor.
The said section also provides that the detention may range from a period of 14 days to a maximum of 10 days, subject to the discretion of the law enforcement agent or military personnel enforcing the detention. It appears that the law basically grants unrestricted authority to the law enforcement agent or military personnel, since what is merely required under the aforesaid section is for the law enforcement agent or military personnel to notify in writing the judge of the court nearest the place of apprehension, as well as the Commission on Human Rights. Now, my question is this: how does the law guarantee that this provision is not subject to abuse?
Your Honor, please. Section 26 provides for safeguards. Section 26 indicates that the law enforcement agents or the military officer must inform the Commission on Human Rights, the judge nearest the place where the suspect was arrested, and also the ATC. Also, Your Honor, that Section 29 provides for imprisonment of 10 years should the law enforcement agent or the military personnel fails to notify the judge or fails to perform any of the acts enumerated in Section 29, Your Honor. The imprisonment is for 10 years, Your Honor.
This is my follow-up here. Does the notification requirement, Attorney Marisa, provided in the law, constitutes sufficient safeguard for the rights of the detained person?
We submit that it is sufficient safeguard for the rights. It is sufficient safeguard, Your Honor.
Now, this 14-day detention, what do you think is the rationale as well as for the 14-day detention, as well as the 10-day extension granted under the law? If you know.
The 14-day detention is necessary to isolate immediately the suspected terrorists so that so as to prevent the commission of acts of further acts of terrorism. Also, Your Honor, this is necessary so that he would not evade he would not evade, and so that we could properly prosecute him.
Okay. Moving on to another topic, ASG. Recently, you must be aware of this, organized of community pantries within Metro Manila were red tagged by law enforcement agencies. It started in Quezon City. There's a place called Maginhawa Street. I think it was a certain Miss Nonan who was, started this community pantry. Such as the National Task Force to End Local Communist Armed Conflict, NTF-ELCAC, without sufficient evidence to prove their alleged connection with communists. Pursuant to this red tagging, Tina Panganiban Perez, a reporter for GMA, asked, ito na siya, si Ana Patricia Non, the organizer of the Maginhawa Community Pantry, if she's affiliated with communists. Now, how will the government ensure that the ATA will not unduly and unlawfully identify any person as a suspect of terrorism merely on the basis of suspicion? My next question, does this incident support the allegations, the petitioner's allegations of future contingent surveillance and red tagging? Please answer.
Your Honor, the government would not like to use the term red tagging because red tagging is a term that that was not coined by the government. It was, if I may say this, Your Honor, the term red tagging was used by the lefties to
So you resent my choice of the word red tagging in my question. Is that what you're trying to point out, Marisa? ASG?
Yes, Your Honor.
So it was wrong for me to do so.
I'm sorry, Your Honor.
Okay, just continue. Hindi na kita didisturbuhin. Go ahead.
Your Honor, red tagging is, the government is firm that what it does is, it is the submission of the government that what it does is truth tagging and not red tagging, Your Honor.
Okay. Okay, last two questions, ASG. The Office of the Solicitor General, your office, is seeking the outright dismissal of the instant petitions on the ground, among others, that a facial challenge based on overbreadth or vagueness is not allowed in penal statutes. it cited the case of Romualdez versus Comelec, where this court indeed held that facial challenges may not be made in ordinary penal statutes and that such an issue may be raised only in free speech cases. Do you follow?
Yes,
Okay.
Your
However, it is noted that while there was such a holding in the Romualdez case, this court still proceeded to resolve the issue of whether or not the law involved in such case should be declared invalid for being vague. It found out that the provisions then in issue were clear. So no ambiguity, you know. And thus this court consequently ruled against striking them out.
Yes, Your Honor.
The same result and finding were obtained in the case of Estrada versus Sandigan Bayan. You're aware of that?
Yes, Your Honor.
Where this court also sustained the precept that facial challenges may be raised only in free speech cases, but nevertheless went on to rule squarely on the issue of alleged vagueness of our law on plunder, a criminal statute. What do you suppose is the rationale behind the principle that facial challenges may be raised only in free speech cases? Well,
Your Honor, may I ask ASC Rigodon to answer your question?
please do so.
Thank you, Your Honor.
Good afternoon, Your Honor.
Were you paying attention when I was during the preliminary to my question? Shall I continue or do I have to repeat the same?
I heard the question, Your Honor.
Oh, okay. It's about the rationale, no, behind this the principle that it is only in free speech cases when facial challenges may be allowed.
The rationale is the chilling effect on free speech, Your Honor.
No, is this rule ASG? You're also on same rank, ASG, no?
Yes, Your Honor.
Tama, no? Now, is this rule absolute, ASG? Or better still, supposing that the challenge provisions in the case I cited, Romualdez and Estrada cases were in fact vague. Kunyari lang.
Yes, Your Honor.
Would there have been anything? Would there have been anything that could have stopped this court from declaring the provisions involved therein to be unconstitutional and striking them out, even if the laws in question did not exclusively pertain to free speech, but rather ordinary criminal action? That's my question.
Your Honor, in the cited case of Estrada, he was actually the petitioner therein was actually charged with the violation of an election law, and therefore, because he can challenge the constitutionality of the said provision of the election law as applied to him on the ground that it violates his constitutional rights, Your Honor.
No, my question, it's a good thing that the court in that case found the criminal statute, which is siguro yung the law on plunder to be clear and not vague.
Yes, Your Honor.
Okay. But my question is this. Halimbawa, just for the sake of argument, if, for example, the challenge provisions in those cases, Estrada and Romualdez, were in reality, or in fact, they are vague. Can the Supreme Court, is the court forbidden from, the declaring the provisions question therein to be unconstitutional and, order them to be stricken out, even if the law in question did not exclusively pertain to free speech, as in this case?
Yes, Your Honor, because in an as-applied challenge, a person can question the constitutionality of a provision of law on the grounds of vagueness, overbreadth, or it violates his right to due process. Unlike in facial challenge, where the grounds for raising such challenge are limited to vagueness and overbreadth, Your Honor.
Attorney, ASG, can we not possibly make an exception in the instant petitions, considering that the cases before us do not involve a pure criminal statute, but rather they allege violations of free speech and other basic rights? How would you respond to that?
Your Honor, like in the Southern Hemisphere case, the law being challenged here, what is being prescribed is conduct and not speech, Your Honor. And following Southern Hemisphere, a facial challenge is not appropriate, Your Honor.
Okay, this is my last question. Under Section 25 of the Anti-Terror Act, Section 25, you're still competent to answer this question about Section 25? Is that part of your assigned topic, Soljen, ASG?
Your Honor, Section 25 is...
sige. Okay lang. Okay na, ikaw na, diyan ka na. The ATC, under that section, is duty-bound to automatically adopt the UN Security Council consolidated list of designated groups and individuals as terrorists or terrorist groups. Moreover, the ATC has been authorized to add to such designation upon request coming from other jurisdictions or supranational jurisdictions, and upon its finding that the criteria under UNSCR number 1373 were met. Okay. Finally, upon a finding of probable cause, the ATC is also authorized to designate individuals and groups after establishing that such individuals or groups are committing or about to commit any of the acts defined under Section 4-12 of the ATA. Consequently, the Anti-Money Laundering Council may thereafter issue a freeze order on their assets. Okay, ASG?
Yes, Your Honor.
Okay. The question is, aside from this freeze order that may be issued by the AMLC, what are the other consequences of the designation made by ATC? If you know.
Under Section 36, Your Honor, wait.
Take your time.
Under Section 35, rather, Your Honor, if there is a designation under Section 25, the Anti-Money Laundering Council is authorized to investigate any property or funds that are in any way related to financing of terrorism as defined and penalized under Republic Act number 10168 or violation of sections 4, 6, 7, 10, 11, or 12 of this act, and B, property or funds of any person or persons in relation to whom there is probable cause to believe that such person or persons are committing or attempting or conspiring to commit, participating in, or facilitating the financing of the aforementioned sections of this act.
Okay, but my question is whether or not you are personally aware of any other consequences aside from the issuance of this order resulting from the designation made by the ATC, meaning the designation of the individuals as what?
Another effect, Your Honor, of such designation is that
terror.
The persons or organization or groups of persons so designated may be the subject of surveillance under Section 6.
Now you're talking. Now, in such cases of designation, is the AATC under any compulsion to file a case for prescription in the Court of Appeals to give the designation judicial imprimatur? Or is this something that can be done away with?
There is no provision in the ATA obliging the ATC to file or to initiate a proceeding for prescription after designation, Your Honor.
Then that would render moot my next question, which is about the time frame. If there is any time frame within which the prescription case should be filed. Nothing in the law. We assailed the ATA.
No. My reading of the Anti-Terrorism Act, Your Honor, there is no mandatory duty.
Okay. If the ATC, as you have explained, is not in fact under any obligation to file a case for prescription following its designation of an individual or group, what then is the remedy available to said entities? Tawag yata sa kanila designees, parang nagde-design, to controvert the designation and thus avoid its consequences, which includes, of course, the AMLC freeze order. Kawawa naman may freeze order
Your Honor, under the implementing rules and regulations of the ATA, there is a procedure for delisting, Your Honor, under Rule 6.9.
So there is a remedy.
Yes, Your Honor.
Okay. Last question. The Solicitor General Counsel is seeking the outright dismissal of the instant petitions on the ground that the issues raised are in the character of political questions. Okay?
Yes, sir.
It is beyond cavil that owing to the principle of separation of powers, political questions are beyond the reach of the Supreme Court. Do you agree? That's quite basic. The good Solgen cited the case of what case? Garcia versus Drilon, where this court pronounced that the exercise of discretion with respect to what motivates Congress to enact a law and how it wishes to accomplish its intentions are matters solely within its prerogative, which the judiciary should not supersede. However, when the same question of jurisdiction was raised in the case of Tanyada versus Angara, this court had the opportunity to clarify succinctly or concisely that where an action of the legislative branch is seriously alleged to have infringed the Constitution, it becomes not only the right, but in fact, the duty of the judiciary to settle the dispute. Ito na ang tanong. The present petitions all raise constitutional questions, echoing a common sentiment that the Anti-Terror Act violates several of the citizens' basic rights. Should the office of the Solicitor General stick to its claim that the present petitions fall exclusively within the ambit of political issues or questions and thus remain to be beyond the reach of this court?
The political question doctrine, Your Honor, is just one of the several grounds that the Office of the Solicitor General raised for the dismissal of the petitions, Your Honor. Specifically, we brought up the matter of political question doctrine in response to the claims of some of the petitioners who argue that there is no need for Congress to enact the ATA because allegedly the Human Security Act of 2007 is sufficient to address the evils of terrorism. So that's why we consider that as a political question because the enactment of the ATA goes into the wisdom of the law, and the enactment was a policy choice on the part of Congress, Your Honor.
Okay. I have no further questions. I would like to thank the Chief Justice for giving me the opportunity to interpolate the Solgen in this oral argument. Thank you, Chief.
Thank you, Justice Rosario. May we call on Justice Samuel Gaerlan to proceed with his interpellation.
Thank you, Chief. I have a few questions and are confined to expanded judicial review and facial challenge, vagueness, overbreadth and speech, judicial writs, privacy and unreasonable searches and seizures, national security, separation of powers, and for its topic, I only have 2 or 3 questions. So, may I proceed, Chief?
You may proceed, Justice Sam. Thank you.
Thank you. Good afternoon, ASG Rigodor. Am I correct, Rigodor?
Yes, Your Honor. Good afternoon to Your Honor.
Good afternoon. Now, let's start with expanded judicial review and facial challenge. And my first question is, in the case of National Federation of Hog Farmers, this is a 2020 case, it clarifies the Geo-Sama ruling in this wise. Even as we try to filter out and dispose of the cases pending in our docket, this court's role is not simply to settle disputes. This court also performs the important public function of clarifying the values embedded in our legal order anchored on the Constitution, laws, and other issuances by competent authorities. Our democracy, after all, is a reasoned democracy, one with a commitment not only to the majority's rule, but also to fundamental and social rights. Even as we recall the canonical doctrines that inform the structure of our Constitution, we should never lose sight of the innovations that our fundamental law has introduced. We have envisioned a more engaged citizenry and political forums that welcome formerly marginalized communities and identities. Hence, we have encoded the concepts of social justice, acknowledged social and human rights, and expanded the provisions in our Bill of Rights. We should always be careful that in our desire to achieve judicial efficiency, we do not filter cases that bring out these values. This court, therefore, has a duty to realize this vision. The more guarded but active part of judicial review pertains to situations where there may have been a deficit in democratic participation, especially where the hegemony or patriarchy ensures the inability of discrete and insular minorities to participate fully. While this court should presume representation in the deliberative and political forums, it should not be blind to present realities. Don't the ATA petitions fall squarely within the court's clarification of Geo-Sama ruling in this case, Solicitor?
Yes, Your Honor, because as the Solicitor General pointed out in his opening statement, there are parties better suited to challenge to bring a challenge to the ATA, and in fact, cases were already filed with the regional trial court, Your Honor, for violation of the ATA, Your Honor.
But because of this case, I'm referring to the National Federation of Hog Farmers, we cannot just outrightly dismiss the various petitions. Am I correct?
I believe that the dismissal of the petition is the should be made by this court because there is no actual controversy, Your Honor, because all the petitions have presented are hypothetical scenarios or anticipatory situations. If this honorable court will allow the petitioners to mount these challenges, it will in effect be giving an advisory opinion, which is something that is outside the function of this honorable court, because its duty is to resolve actual cases, Your Honor, based on concrete facts.
Okay. My second question is, what is your proposed definition of a chilling effect? Is it consistent with the court's duty of expanded judicial review under Article 8, Section 1 of the Constitution, in line with the statement in Imbong versus Ochoa, wherein it states that while this court has withheld the application of facial challenges to strictly penal statutes, it has expanded its scope to cover statutes not only regulating free speech, but also those involving religious freedom and other fundamental rights. Unlike its counterpart in the US, this court, under its expanded jurisdiction, is mandated by the fundamental law not only to settle actual controversies involving rights which are legally demandable and enforceable, but also to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of government. Fairly, the framers of our Constitution envision a proactive judiciary ever vigilant with its duty to maintain the supremacy of the Constitution. So what is your proposed definition of a chilling effect? Is it consistent with our court's duty of expanded judicial review?
Our position is the chilling effect doctrine should only be confined to free speech cases and not to penal statutes that prohibit or regulate conduct, as in the Anti-Terrorism Act, Your Honor. As pointed out in the Designating case, every penal statute has an inherent chilling effect because of the threat of prosecution or interim, as case law defines it, because of interim effect. Therefore, because of the inherent chilling effect of every penal law, to allow facial challenge to every penal statute would open the floodgates to frivolous suits and clog the dockets of courts. And therefore, our submission is that insofar as penal statutes are concerned, it should be challenged in an as-applied challenge, Your Honor, and not by virtue of a facial challenge, Your Honor.
I will ask you questions later about conduct and speech. Okay, but I may ask you first about vagueness, overbreadth, and speech. Okay. What is a serious risk to public safety? Justice Cardelesa's dissent in Lagman versus Pimentel, the 2018 case, lists the various understanding of safety in Philippine law, which I quote. Public safety, for example, has been interpreted to be synonymous with the concept of national security and security of the state, but narrower than those matters falling under the concept of interests of the state. On the other hand, dangers to public safety have been held to include traffic congestion, hazards of traffic in the evening, business establishments which give rise to conflagrations and explosions, open canals, manholes, live wires, and other similar hazards to life and property, presence of motorcycles in tollways, billboards, and signages in times of typhoon, unrestricted right to travel of court employees, and the failure of railroad companies to install, maintain, and repair safety equipment and signages. Do any of these enumerations fall under the OSG's understanding of a serious risk to public safety?
With respect to the Anti-Terrorism Act, Your Honor, some of the instances that Your Honor mentioned may not be the one relevant to the concept of public safety insofar as terrorism is, insofar as the Anti-Terrorism Act is concerned, Your Honor.
Okay. Now, Section 4 criminalizes a dangerous rally criticizing the government, correct?
Can you kindly repeat the question, Your Honor?
Section 4 criminalizes a dangerous rally criticizing the government, but not a dangerous rally supporting the government. Does this not support petitioner's point that law enforcement officers are given authority to make the law as they implement it? Does this not make the law content-based?
On the first question, Your Honor, insofar as rallies are concerned, for that rally to be considered as punishable under Section 4, it must be intended to cause either to cause death or serious bodily injury to any person, or it will the holding of the rally was intended to cause extensive damage or destruction, or any of the or if the rally was intended to cause extensive interference with or damage or destruction to critical infrastructure, and the purposes or any of the purposes mentioned in the second paragraph of Section 4 is present, Your Honor, that rally, regardless of the whether it was for the pro-government or anti-government, that's the only time that rally can be punished under Section 4, Your Honor. If the intent and purpose are not present, then the rally, regardless of whether it is in favor of the government or or against the government, then it cannot be punished under Section 4, Your Honor.
So even if the rally is in support of the government, as long as it is a dangerous rally, is that what you mean?
No, Your Honor, if the overt act punished under Section 4 and the purpose mentioned in the second paragraph of Section 4 are present, then that rally can be punished as an act of terrorism under Section 4. If the intent and purpose are not present, then the rally, regardless of whether it is in favor of the government or against the government, cannot be punished as an act of terrorism under Section 4, Your Honor.
Okay. Now, let us, as a follow-up question to the topic on conduct and speech. Now, you argued that the ATL penalizes conduct, not speech, correct?
Yes, Your Honor.
But isn't conduct a form of speech? Conduct can be considered symbolic speech, as stated in the case of Ibralinag versus Division Superintendent of Schools of Cebu. That is a 1993 case. Conduct can be considered symbolic speech.
Yes, Your Honor.
So you are now changing your answer that it's not only conduct that is penalized by ATL, but also speech.
Your Honor, symbolic conduct as symbolic speech is still part of speech, Your Honor, but the conduct that is being prescribed by the ATA is conduct that does not invite a dialogue or a public debate, but conduct that produces violent action, Your Honor.
Okay. Can the text of the ATL cover protected speech?
Your Honor,
because if the ATL covers speech, does the presumption of constitutionality still apply?
no, under the ATA, the punishable conducts under the punishable conducts under the ATA, speech is merely an incident, Your Honor. And therefore, what is being punished is not speech, but conduct, Your Honor.
So what test should this court apply in weighing the constitutionality of this law?
Since
okay, let's move on to another question, Solicitor. Okay. Now, the last proviso of Section 4 states that advocacy, protest, dissent, stoppage of work, industrial or mass action, and other similar exercises of civil and political rights are not included in the definition of terrorism, correct?
Yes, Your Honor.
However, the proviso further adds a qualifier, which are not which I quote, which are not intended to cause death or serious physical harm to another person, to endanger a person's life, or to create a serious risk to public safety. By simple grammar, does this not mean that exercises of civil and political rights can be considered terrorism if they are intended to cause death or serious physical harm to another person, to endanger a person's life, or to create a serious risk to public safety?
What the second paragraph did, Your Honor, is that if the exercise of a civil political right, if the prosecution can establish that the claimed exercise of civil and political rights is really intended to cause death or serious physical harm to a person, or to endanger a person's life, or to create a serious risk to public safety, then such exercise is no longer a protected activity, but an unlawful conduct, Your Honor. As an unlawful conduct, the state has a right to punish such conduct, Your Honor.
And who determines this intent? Who determines the intent?
The prosecution, Your Honor. The prosecution can present rebuttal evidence that the claim exercise of civil and political rights was really intended to cause death, for example, or serious physical harm.
So there is no presumption that as to the intent. It has to be it has to be determined by the prosecution.
Your Honor, since advocacy protest dissent is a matter of defense, which an accused may not even raise if the accused, for instance, raises the defense of alibi or mistaken identity, then there is no need for the prosecution to present evidence that the exercise of the civil and political right was really intended for some harmful purposes, Your Honor. And therefore, the state has no initial obligation, or the prosecution has no initial obligation to establish that the overt act was not an unlawful exercise of a civil and political right, because the prosecution has no way of anticipating what the accused might raise as a defense, Your Honor.
Okay, let's talk about material support. Okay, material support is so widely defined as to include almost every day-to-day transactions, even if it is unrelated to the alleged terrorist activities that are being committed. It can include independent, otherwise legal advocacy, like political campaigning or even paying for legal representation. How is this permissible?
Your Honor, the rationale for prescribing such act, Your Honor, is to prevent the terrorist groups or individuals from having access to resources which can aid them in launching terrorist attacks, Your Honor.
Okay. Now, Brandenburg is the applicable free speech test in this jurisdiction. Am I correct?
Based on my survey of Philippine case, Your Honor, according to Chief Justice Puno, it's the clear and present danger rule, Your Honor, that is being applied.
Okay. Now, how can you say that all the speech penalized by the law, specifically under the sections prohibitions proposal, conspiracy, inciting and planning, training, preparing, etc., is directed to inciting or producing imminent lawless action and is likely to incite or produce such action? Is merely proposing an anti-government rally that could turn violent already likely to incite lawless action? Can the utterance be considered a form of terrorism punished by this law? And what separates utterances that are harmless from actual conduct sought to be prohibited by this law?
The offenses you mentioned, Your Honor, are what we considered as inchoate crimes or preparatory crimes, Your Honor. The purpose for punishing these acts is to prevent terrorism at its inception, Your Honor.
And who makes the determination?
For apprehension, Your Honor, the law enforcers and the military personnel. For the existence of whether or not there is probable cause to charge them, it is the public prosecutor, Your Honor.
Okay. Now, I'm sure you have read and studied the IRR of the ATA. The IRR has made many changes to the law, such as but not limited to one, adding the qualifier of quote intended to cause a disproportionate amount of damage to the terrorist act of developing, manufacturing, etc., weapons or explosives. Two, including creative, artistic, and cultural expressions as acts that may be considered terrorism. Three, adding the qualifier of with knowledge and intent to the crimes of possession of objects and preparation of documents in relation to planning for terrorism. Four, adding the qualifier of having a reasonable probability of success in inciting the commission of terrorism to the crime of inciting terrorism. And five, adding the qualifier intentionally or knowingly to the act of recruitment. Are these additions ultra vires for expanding or limiting the crimes in the law? And if not, are they not admissions by the government that the law as written is vague and overboard?
Submission is that the IRR is the proper implementation of the law, and in so implementing the ATA, the IRR uh, uh, merely provided parameters that would ensure that there would be no arbitrary apprehension or arbitrary prosecution, Your Honor. It is in fact a safeguard, Your Honor.
Okay, let's move on to judicial writs. Now, if a person is detained on the basis of the ATC's authority, will an application for a writ habeas corpus prosper, or will it be held to the same standard as applications for writ of habeas corpus for people restrained by a legal process?
If there is an ATA authorization for an extended detention, Your Honor, a habeas corpus will not lie, Your Honor, because the a habeas corpus proceeding inquires into the validity of the detention. And since such extended definition is authorized by Congress itself through the mechanism of the ATC, Your Honor, then the detention would be valid, and therefore the writ will not issue.
Okay. Now, the remedy for a person who suspects groundless surveillance is to file a writ of habeas data. Is this an effective remedy?
Yes, Your Honor.
Why?
Because the party filing, the party availing of such remedy can ask the court to destroy the unauthorized data which were obtained illegally, or if the data in the possession of the government is erroneous, the party can ask for a rectification, Your Honor.
Okay. Now, let's move on to privacy and reasonable searches and seizures. Okay. My first question is, many things that can be considered weapons under Section 4, Paragraph D, may also be lawfully possessed, such as knives or baseball bat. Does this not authorize unbridled discretion to search people possessing such objects based on mere reasonable suspicion that they may be carrying such weapons to intimidate people?
As a general rule, Your Honor, a search to be valid must require a warrant from the court. However, there are recognized exceptions to this, such as a search incidental to a lawful arrest, Your Honor. a search in plain view, a search under exigent circumstances, the and
So you're talking about warrantless arrest or searches. Now, for the purposes of a warrantless arrest or search, how will the policeman distinguish when an act, by its nature and context, fulfills any of the purposes under Section 4 of the law? What is the amount of context required for the policeman to personally witness in order for the objective desire to obtain a specific result that must be present in order to determine the intent?
Can I give an example, Your Honor, to answer your question?
Yes, please. Yes.
For instance, a police officer apprehended a person carrying an improvised explosive device. And upon a search of the body of that person, they were able to retrieve documents showing the plans of that person, detailing on where, when that improvised explosive device will be used. And let's say the police were also, the police officer and also, let's say the police officer has also recovered documents detailing the plans and the purpose of that person in detonating the bomb that is carrying. That will give the police officer sufficient cause, probable cause, to believe that that person is engaged in terrorism as defined in Section 4, Your Honor.
Okay. But, now, in the national security, I'm just being curious. Why were there no SSA prosecutions related to the Marawi seats?
Verify that, Your Honor, with the NSA, Your Honor.
Okay, it's okay. It's okay then. Okay, let's move on to Rule 9.2 in relation to Section 29. Isn't the IRR's inclusion of the grounds under the rules of court for warrantless arrest in Rule 9.2 an admission that Section 29 is unconstitutional as written in the law?
Your Honor, may I refer that question to my colleague, ASG Calendines?
Yes, please.
Good afternoon, Your Honor.
Good afternoon, my fellow Bedan.
Yes.
Now, did you hear my question, ASG Gorandines?
Rule 113.
Now, isn't the IRR's inclusion of the grounds under the rules of court for warrantless arrest in Rule 9.2 an admission that Section 29 is unconstitutional as written in the law? Because is this not also the interpretation of the OSG of Section 29 as including the grounds for warrantless arrest in the rules of court? That is your consolidated comment, page 190 to 191.
Correct, Your Honor. Warrant detention under Section 29 follows a valid warrantless arrest, Your Honor.
So are you not asking the court to unreasonably stretch the interpretation of the law in order for it to be valid?
No, Your Honor.
Why?
Your Honor, we submit that Section 29 is clear. Section 29, detention under Section 29 follows a valid warrantless arrest. Valid warrantless arrest as enumerated in Rule 113, Section 5 of Rule 113 of the Rules of Court, Your Honor.
Okay. Now, how can you claim that Section 29 is intended to investigate and stamp out terrorist attacks before they begin, when the OSG's interpretation of the same provision, I'm referring to consolidated comment page 199, would require a law enforcer to secure written authority from the ATA only after the grounds for warrantless arrest are present. Isn't this a contradiction?
We do not believe that there is a contradiction, Your Honor. The authority is given so that the law enforcement agents or the military personnel could validly extend the period of detention without fear that they are violating the rule on arbitrary detention, Your Honor.
Okay. Now you claim that the judge's power to determine the existence of probable cause is not transgressed by the ATC's grant of authority to detain suspected persons under Section 29 because suspected persons are people validly arrested but not yet charged. In your consolidated comment, page 190, it states that under the Anti-Terrorism Act, the person arrested and detained after a warrantless arrest is suspected of committing the crime of terrorism. Has this interpretation of suspected been upheld or applied before? And how is this a reasonable interpretation since Section 29 says having taken custody of a suspected person? Clearly, they are taken into custody because they are suspected, not suspected because they have been taken into custody. Isn't the power of to determine a probable cause for arrest vested upon a judge?
Your Honor, the word suspected in Section 29 actually pertains to a person who is not yet formally charged with violation of Anti-Terrorism Act, but nonetheless has been arrested and detained under any of the circumstances justifying warrantless arrest.
Okay, now, what else? Okay, I think I have no more questions. Thank you, ASG Gulandines, and my son Shalom was your former student in San Pedro College of Law. And thank you. Thank you, Chief.
Thank you, Your Honor.
Thank you, Justice Sam. May we call Justice Edson de los Santos to proceed with his interpellation.
No, the host is not allowing.
Proceed.
Thank you very much, Chief. Hello, Chief. Thank you so much.
Go ahead, Justice Edsa.
Okay, Chief. I have a few questions, Chief, since some of the questions that I was supposed to ask were already asked by the esteemed colleagues earlier. And I think my questions will be better addressed to ASG Galandines, because I'll be asking questions based on Section 25, Section 29, and Section 34 of the Anti-Terror Act. ASG Galandines, please.
Yes, good afternoon, Your Honor.
Yes, good afternoon, ASG. I heard earlier that you started working at the Office of the Solicitor General in 2008.
January of 1992, Your Honor.
1992, I stand corrected. Now, my first job would have been at the Office of the Solicitor General also, way back in April 1978. Perhaps you were still in high school or elementary. That was April 1978 after I signed the roll of attorneys. It was upon the encouragement of then professor of the UP College of Law, Professor Benvenido Ambion. But as fate would have it, my first job was in the judiciary, the Court of First Instance, Branch 39 of Manila. At any rate, as I've said, I have only very few questions, ESG. This pertains to Section 25. I have only about 3 questions. Now, in Secretary of Justice versus Lanchon, the court had the occasion to rule that the basic rights of notice and hearing pervade not only in criminal and civil proceedings, but in administrative proceedings as well. Non-observance of these rights will invalidate the proceedings. Individuals are entitled to be notified of any pending case affecting their interest, and upon notice, they may claim the right to appear therein and present their side and to refute the position of the opposing parties. Moreover, the court therein held that even in administrative investigative proceedings, such as a preliminary investigation, under Section 3, Rule 112 of the Rules of Court, guarantees the respondent's basic due process rights, granting him the right to be furnished a copy of the complaint, the affidavits, and other supporting documents, and the right to submit counter affidavits and other supporting documents within 10 days from receipt thereof. Likewise, the respondent shall have the right to examine all the evidence submitted by the complainant. Now, the evaluation process conducted by the ATC to determine the necessity of designation partakes the nature of a criminal investigation, or at least a tool for criminal law enforcement. Considering that the possible consequences of designation are criminal in nature, example, warrantless arrest and detention, and deprivation of property, as designation may trigger the issuance of a freeze order and bank inquiry. My question is this: is it not indispensable that due process requirements be complied with, such as notice and opportunity to be heard?
Your Honor, we submit that designation under Section 25 is an executive and administrative function of the ATC, and there is no encroachment on the judicial powers. And therefore, the designation does not amount to conviction. No penalty is automatically attached to the performance of that executive and administrative function, and therefore, there is no transgression of the due process principle found in our Constitution, Your Honor.
Notwithstanding my earlier statement that it could result into possible consequences of the possible consequences such as criminal in nature, like warrantless arrest and detention?
It is our submission that designation does not require the production and weighing of evidence. After all, designation does not amount to conviction, Your Honor. It is
in other words,
Your
any
Honor,
court proceeding short of conviction will be allowable under the Anti-Terror Act.
Your Honor, can you kindly repeat that?
What I'm saying that based on this power of the ATC to designate, as long as it has not reached to the point of convicting the accused, it still is not a violative of this particular provision, or rather the provision regarding due process.
Yes, Your Honor, because designation is merely a tool to facilitate the issuance of a freeze order, Your Honor. That is why there is no notice and hearing in designation, Your Honor.
And thus, there is no violation of due process.
Yes, Your Honor, there is no violation of due process, Your Honor.
Okay. Under Section 25 of the Anti-Terrorism Act, the ATC may designate an individual, groups of persons, organization, or association, whether domestic or foreign, upon a finding of probable cause that the individual, groups of persons, organization, or association commit or attempt to commit or conspire in the commission of the acts defined and penalized under sections 4, 5, 6, 7, 8, 9, 10, 11, and 12 of the Act. Now, the question is this: is there no undue delegation of powers with respect to the ATC's power to designate?
Your Honor, your question was there undue delegation of power,
Yes.
Your Honor?
Since notably the law is silent with regard to the procedure on how the ATC will arrive at its conclusion, and what evidence or quantum of proof will it use to determine whether to issue an order of designation, among others. Now, is there no undue delegation of powers with respect to the ATC power to designate?
Submit that there is no undue delegation of power, Your Honor. For purposes of delegation under for purposes of delegation, the implementing rules and regulations under 6.2 and 6.3 provides for the procedure for domestic designation, provides for the rules to be followed for domestic designation, Your Honor.
Okay. My last question under Section 25. How does the judicial function of determining probable cause for the issuance of arrest warrants differ from the alleged executive function of determining probable cause in designating and detaining suspected terrorists?
Your Honor, for purposes of designation under the ATA, probable cause shall refer to a reasonable ground of suspicion supported by circumstances warranting a cautious person to believe that for purposes of making the designation, the designing meets all the qualifications, the requirements rather, for designation.
So would you admit that the requirements with respect to determination of probable cause in the provisions of the APA is less compared to the determination of probable cause before a judge?
Yes, Your Honor. There is a difference between probable causes determined by the judge and the probable causes determined by the envisioned by the Anti-Terror Act of 2020, Your Honor.
I will now proceed to Section 29 of the Anti-Terror Act on the power to authorize arrest and detention without judicial warrant. Section 29 of the said law states that any law enforcement agent or military personnel who has been authorized in writing by the Anti-Terrorism Council, or ITC, shall arrest and detain without warrant persons suspected of violating the law for a period of 14 calendar days, which period can be extended to a maximum of 10 calendar days, or 24 calendar days in total, if it is established that further detention is necessary to preserve evidence and prevent the commission of another terrorism. It also states that the law enforcement agent or military personnel shall not incur liability under Article 125 of the Revised Penal Code for the delay in the delivery of detained person to the proper judicial authorities. Now, my first question is, the maximum period of 24 days is approximately the length of imprisonment for light felonies or crimes punishable by arresto minor, period of 1 to 30 days. Now, would this not be violative of the constitutional prohibition that no person shall be held to answer for a criminal offense without due process of law? Because effectively, a person detained will be deprived of liberty even without a judgment by a court of law, finding him guilty beyond reasonable doubt.
Your Honor, we submit that detention contemplated under Section 29 is a class of its own. It is different from the detention contemplated by Article 125 of the Revised Penal Code.
So my question is this, since a person has been convicted for light felonies or crimes punishable by mere arresto minor, which is a period of 1 to 30 days. Now, his conviction occurs after a full trial. Now, whereas in the provision of this ATA, there was no trial yet, and the person is already detained for 30 days. That is, may I know what is your opinion on this?
Your Honor, compared to a person who was convicted for a
light felonies.
For life
Chapter 5.
the Anti-Terrorism Act was enacted to protect life, liberty, and property from terrorism, to condemn terrorism as inimical and dangerous to the security of the country and to the welfare of the people. So I do not think, Your Honor, that we could rightfully compare this to a person who was convicted for a violation of for a light offense, Your Honor.
So in short, the gravity of the offense can be an excuse or a justification.
We submit so, Your Honor. There is clearly a legitimate purpose behind Section 29. It renders Your Honor, please, the period of detention is proportionate to the crime committed, which is, or the crime sought to be prevented, which is terrorism, Your Honor. And therefore, we submit, Your Honor, that this could not be compared to a light offense, Your Honor.
So you're now equating to a crime committed and the crime sought to be prevented as a justification.
Yes, Your Honor, for the continued detention, Your Honor.
Okay, I will proceed to my next question. Is it correct to state that as presently worded in the Anti-Terror Act, nothing would prevent law enforcement from releasing a person initially detained for the maximum 24 days from being released and again apprehended and detained for another 24 days?
Your Honor, we submit that if the law enforcement agents would find sufficient grounds to release the suspect, then he may rightfully do so. If that same suspect would commit an act that would justify again a valid warrantless arrest, then that suspect can again be arrested. He having committed another offense that would justify a valid warrantless arrest under Rule 113. If he does it all over again, then, Your Honor, he could be rearrested, Your Honor.
Okay, I will now proceed on my next question. The Office of the Solicitor General, in its consolidated comment, states that despite the use of suspected person in the law, it does not signify an abandonment of the threshold of probable cause as the standard for a valid warrantless arrest. If this were the case, why would it be necessary to authorize another 14 to 24 days to complete investigation or to gather evidence to support a criminal charge?
Your Honor, additional days of detention are justified in this crime of terrorism so that we could prevent further commission of the same acts. We could isolate the suspect from his other members or his cohorts, and so that we could proceed with the case build-up so that when we do file a case before the proper authorities, then there is certainty that our case would stand, Your Honor.
Okay. Likewise, Section 29 requires the law enforcement agent or military personnel to notify in writing the judge nearest the place of apprehension or arrest of the following facts. 1, the time, date, and manner of arrest. 2, the location or locations of the detained suspects. And 3, the physical and mental condition of the detained suspects. To recall, under Section 5, Paragraph 5 of Article 8 of the Constitution, only the Supreme Court may promulgate rules concerning the protection and enforcement of constitutional rights, pleading, practice, and procedure in all courts. My questions are these. First, did Congress intrude on the exclusive rulemaking power of the Supreme Court by directing judges to receive written notices of the suspected terrorist apprehended under warrantless arrest under Section 29?
Your Honor, we submit that this was included as a safeguard. Your Honor, in the previous anti-terror law, there were issues raised about violations of human rights. This was included in the present anti-terror law to assure those who are suspected and those who are being detained, that their human rights are to be observed. And this, Your Honor, this is a safeguard provided for by the Anti-Terror Act of 2020.
My next question. Can Congress, through the Anti-Terror Act, impose an additional function on judges without the authority or consent of the Supreme Court? Moreover, in this case, did the Anti-Terror Act effectively reduce the function of a judge to a receiving clerk, as nothing in the Anti-Terror Act states that the judge concerned would be determining whether there is probable cause to detain the suspected terrorist or to overrule the ATC's written authority ordering his arrest?
Your Honor, we submit that the judge was not given the role of determining whether the continuous detention is warranted. The judge, as mentioned in Rule 9.3 and as mentioned in Section 29, was was to be notified of the fact that there is a person held for questioning by the law enforcement agents, and this person could probably be charged for terrorism, but there is no additional function imposed upon the judge, Your Honor.
Okay. My last question under Section 29 of the Anti-Terror Act. It is alleged that Section 29 of the Anti-Terror Act on detention without judicial warrant of arrest fall under recognized instances whereby a valid warrantless arrest may be effected. Example, for example, flagrante delicto and hot pursuit, as what is authorized in other crimes. Now, if that is the case, why was it necessary to include this provision in the Anti-Terror Act when such authority to arrest a person under such circumstances already exists under the rules of court and affirmed by jurisprudence?
Your Honor, I submit that there is no prohibition on simply.
Is this not superfluous?
We do not think that this is superfluous, Your Honor. There is nothing that would prohibit a detailed enumeration of Rule 113 through the IRR, Your Honor. That was just a reiteration, and Section 29 is not a warrant of arrest, Your Honor. We do not think there was something. There was nothing wrong with the implementing rules and regulations. Still, mentioning what is contemplated under Rule 113 of the
Rules of Court.
Yes, Your Honor.
Okay. This is my last question under Section 29. Does not the fact that a prior written authority from the ATC must first be obtained before causing the arrest or detention of a suspected terrorist imply that there was no immediate need to obtain custody over his person? In short, since the arresting officers or military personnel have personal knowledge of the commission or an ongoing commission of an act of terrorism, could they have not obtained a warrant of arrest instead of a written authority from the ATC?
Your Honor, there are instances when the law enforcement agents or the military personnel would not have the luxury of time to go to court and ask for a warrant of arrest. We are dealing with terrorism, Your Honor. Time is of the essence. This must be nip in the bud. So if the law enforcement agents or the military personnel would receive information, they should immediately effect a warrantless arrest rather than go to court. After all, Your Honor, if they go to court, it might prejudice the government operation. It might prejudice government operations.
Okay. Let me now proceed to Section 34 of the Anti-Terror Act on restriction of the right to travel. Section 34 of the Anti-Terror Act provides that In cases where evidence of guilt is not strong and the person charged is entitled to bail and is granted the same, the court, upon application by the prosecutor, shall limit the right to travel of the accused within the municipality or city where he or she resides, or where the case is pending, in the interest of national security and public safety, consistent with Article 3, Section 6 of the Constitution. He or she may also be placed under house arrest by order of the court at his or usual place of residence. While under house arrest, he or she may not use telephones, cell phones, emails, computers, the internet, or other means of communication with people outside the residence until otherwise ordered by the court. Now, bail is the security given for the temporary release of a person who has been arrested and detained, but whose guilt has not yet been proven in court beyond reasonable doubt. Now, in the case of Padua versus People, it is said that the right to bail is cognate to the fundamental right to be presumed innocent. And as explained in that case, it is said, it must be emphasized anew that bail exists to ensure society's interest in having the accused answer to a criminal prosecution without unduly restricting his or her liberty and without ignoring the accused's right to be presumed innocent. It does not perform the function of preventing or licensing the commission of a crime. The notion that bail is required to punish a person accused of crime is therefore fundamentally misplaced. Indeed, the practice of admission to bail is not a device for keeping persons in jail upon mere accusation until it is found convenient to give them a trial. The spirit of the procedure is rather to enable them to stay out of jail until a trial with all the safeguards, as found and adjudge them guilty. Unless permitted this conditional privilege, the individuals wrongly accused could be punished by the period of imprisonment they undergo while awaiting trial, and even handicap them in consulting counsel, searching for evidence and witnesses, and preparing a defense. Hence, bail acts as a reconciling mechanism to accommodate both the accused's interest in pre-trial liberty and society's interest in assuring his presence at trial. Question. As presently worded under Section 34 of the Anti-Terror Act, a suspected terrorist, even after being granted bail, because evidence against him is not strong, may be further burdened by being placed under house arrest at his residence. Does this not defeat the purpose of a bail? After all, the purpose of bail is only to secure an accused's presence at trial. To reiterate the court's ruling in Padua, bail does not perform the function of preventing or licensing the commission of a crime.
Your Honor, we submit that the right that this does not violate his right to bail. The right to travel is not absolute. The Constitution provides that the right to travel may be impaired in matters in the interest of national security, public safety, or public health, as may be provided by law. Clearly, Your Honor, the Anti-Terrorism Act cannot be denied that this is terrorism, Your Honor, and therefore the state has a right that since this is terrorism, Your Honor, the state has the constitutional, statutory, and inherent right to limit an individual's right to travel, Your Honor. And Your Honor.
Okay. Again, pertaining to the right to restrictions to the right to travel. The rationale for restrictions to the right to travel was aptly explained in the case of Garcia versus Sandigan. A court has the power to prohibit a person admitted to bail from leaving the Philippines. This is a necessary consequence of the nature and function of a bail. Under Rule 114, Section 1 of the Rules of Court defines bail as the security required and given for the release of a person who is in the custody of the law, that he will appear before any court in which his appearance may be required as stipulated in the bail bond or recognizance. Its object is to relieve the accused of imprisonment and the state of the burden of keeping him pending the trial, and at the same time to put the accused as much under the power of the court as if he were in custody of the proper officer, and to secure the appearance of the accused so as to answer the call of the court and do what the law may require of him. The condition imposed upon petitioner to make himself available at all times whenever the court requires his presence operates as a valid restriction on his right to travel, as we have held in People versus Hoy Toy Singh. The result of the obligation assumed by appellee surety to hold the accused amenable at all times to the orders and processes of the lower court was to prohibit said accused from leaving the jurisdiction of the Philippines, because otherwise said orders and processes will be rendered nugatory, and inasmuch as the jurisdiction of the courts from which the issue does not extend beyond that of the Philippines, they would have no binding force outside of the jurisdiction. Upon posting bail, the accused subjects himself to the jurisdiction of the court and may validly be restricted in his movement and prohibited from leaving this jurisdiction. He cannot leave the country without the permission of the court where his case is pending. Remember that the grant of bail merely secures provisional or temporary liberty under conditions set by the court. And the court may recall said grant and return the accused to detention should he violate the conditions for his temporary liberty or when reasons for the lifting of his bail arise. It is undisputed that courts have the power to prohibit a person admitted to bail from leaving the Philippines, otherwise he may be placed beyond the reach of court. However, can the same justification be used to restrict a person to the municipality of his residence or his house? Is this consistent with Article 3, Section 6 of the Constitution?
Your Honor, we submit this is a little inconvenience. This is a little inconvenience, a small price to pay for what? For public safety. If the terrorists would be allowed to travel outside in an area where he would be outside the reach of law enforcement agents, then he might commit another act of terrorism, and the state obviously has the right to always ensure safety, the safety and security of its people. So his limitation on right to travel is, may we submit, a little inconvenience compared to the issue of national security and safety.
Compared to the evil sought to be protected or avoided? Compared to the evil sought to be avoided?
Yes, Your Honor.
Okay. Thank you, H.G. Galandines. That was my last question. Thank you very much, Chief. Thank you very much, Chief.
Thank you, Justice Edsa. Justice Mario Lopez will follow for the interpellation. Justice Mario.
Thank you, Mr. Chief Justice. Justice, Madam Solicitor, do you hear me?
Yes, Your Honor. Good afternoon.
Don't worry, I will not go beyond 30 minutes. I will limit already my privilege to interpolate. And I will be very basic and concentrate more on the provisions of Article 4. At the commencement of the interpolation for the solicitor, I mentioned before this court about the dichotomy of the crime of terrorism compared to other crimes. Did you take note of that, solicitor?
Yes, Your Honor. But Your Honor, please, may I ask ESC Rigodon to take this to take the.
There's no question yet, solicitor. Any one of you may answer me. No problem. You can. I think you can answer my question because it is simply saying that the case of Southern Hemisphere will take precedence of all other jurisprudence because this is the only decision of the court that directly involve national security.
I agree.
And that decision, that Desini case does not involve national security. That is my proposition.
And we agree, Your Honor.
You agree. Since it is only Southern Hemisphere, can we carve a new rule, or perhaps provide a guidance that is relevant to the case of Southern Hemisphere? Or totally we cannot do away with the decision in that case of Southern Hemisphere?
Your Honor, I'm sorry, Your Honor, did I get it correctly that the question was, should you abandon the ruling in Southern Hemisphere?
Can we totally disregard? Because I said will take precedence.
Yes, Your Honor.
And since the ruling there was that it is a criminal law ad terrorim in character,
Yes, Your
we
Honor.
cannot do a judicial review for reasons involving procedural matters.
Yes, Your Honor.
All right. Now, can we modify, or is the court, or are you, or do you agree that there may be a modification of the Southern Hemisphere rule?
Your Honor, the present case and the case of Southern Hemisphere are practically the same.
Yes, yes. That's why I am asking you if we can carve out a different ruling from that of Southern Hemisphere, given the distinction of the old law and the present terrorism law.
No, Your Honor, because the
All right.
subject and the concerns raised.
There's no need to explain, Madam Solicitor. I will approach this problem in a very simple manner.
Yes, Your Honor.
If there is a law which is infirm, why? Because it is vague. We, the citizens, cannot understand, and even the law enforcers cannot understand because of its vagueness. For that reason, what is the remedy of a citizen or those involved in the enforcement of the law so that they could be guided accordingly by that legislative enactment? What is the remedy so that they could be properly guided by that enactment, especially so that the law involves a criminal offense and it involves their liberty, freedom, or even their lives?
Hypothetically, Your Honor, if the ATA is vague.
No. I am approaching it in general manner, and we will go to that specific law ATA later on.
Yes, Your Honor.
This will involve some procedural issues that we will deal on as we go on in the interpolation.
Yes, Your Honor.
So what would be the remedy for the citizens and enforcers so that they could be guided accordingly by that vague law governing their life, liberty, and even property, considering that it is a criminal offense? No remedy.
I believe, Your Honor, if
there is no remedy,
if they find the provisions of the law to be vague, then
okay, I will continue. Under our jurisprudence, there are two approaches which is being considered One is the void for vagueness rule, and the second one is the as applied challenge. Is that correct?
Correct, Your Honor.
All right. So which of these two mode of challenge may be applied if there is a vague law that we cannot understand and it regulates our conduct, not only our speech, but conduct as well, and there is a prejudice that is being or will be done to our life, liberty, and property. As applied or void for vagueness. Of course, I know what are the limitations. You know whether this challenge is applicable or not. And that is why I am now asking and proposing, not proposing, but I am now asking if we could possibly carve out a different or a new manner or way in order to correct that law which is infirm.
Your Honor, a applied challenge is more traditional. The
Yes.
petitioner who claims a violation of the constitutional right can raise any constitutional ground, absence of due process, lack of fair notice, and the likes. One can challenge the constitutionality of a statute only if he asserts a violation of his own right.
All right. In other words, what you are saying, Madam Solicitor, is that void for vagueness rule, nor as applied challenge cannot be applied or cannot be used.
No, Your Honor. Not in this particular case, Your Honor.
It cannot be. All right. Let me take this proposition of as applied. What do you understand by as applied?
As your
applied challenge, yes.
As Your Honor explained during the last hearing, in the previous hearings, Your Honor, as applied, as exemplified by the case of Estrada versus Sandigan Bayan, as former President Estrada, as applied challenge was used in that proceeding because President Estrada was himself accused of plunder.
Yes.
That is the as applied challenge, as you exemplified in the previous hearing, Your Honor.
Yes. I am now asking if we can carve a new rule. For instance, in this case of terrorism, because of its dichotomy and uniqueness, if there are possible vague provisions, can we adapt the as applied challenge? Because terrorism is not only imminent, but in fact, it is already happening. And the court can take judicial notice internationally or domestic-wide. There is a terrorism that is ongoing. Of course, we are of judicial notice involving the Marawi and the Holo incident, among others. And since it is already here before us, present, can we similarly apply the challenge involving as applied doctrine?
In this case, we submit no, Your Honor, because there are other parties who are not before this court with more direct and specific interest in the questions being raised.
No problem, Madam Solicitor. I'm just asking this possibility because of the strict character of judicial review involving this procedural matter, so that if this terrorism law will not pass these procedural issues, then everything will become moot and academic. Correct? In fact, this is the first obstacle before this court could exercise its power of judicial review. The procedural issues.
I submit, Your Honor.
Yes. As in fact, in the Southern Hemisphere, the court did not totally decided the issues presented because of some procedural obstacles.
We agree, Your Honor.
Yes. Now, if I may go to the provisions of Section 4, since this is the heart and soul of the Terrorism Act, not necessarily that it will invalidate the other provision. If Section 4 will be rendered void or unconstitutional, it is, to me, is the most important provision of the ATA, correct?
Correct, Your Honor. That is,
Yes.
may I be allowed
Yes.
to give the
In fact, the good Solicitor General Kalida astutely explained the physical constituent of terrorism, which involved the actus reus and the mens rea. To be more specific, actus reus is the subjective element because the offender has to perform an act, and the mens rea is the objective element because that is the intention or purpose of the offender. So that absent of one element, such crime of terrorism will not occur. Correct?
We agree, Your Honor.
Yes. And one of the objections of the petitioner is that the ATA is a crime of intentions. That even a person intending to commit a crime is already liable. How will you respond to that? A crime of intention, so that mere intention on the part of the offender is already a crime. You did not hear the petitioners assailing that provisions involving Section 4, which is a crime of intentions, because the actus reus mentions of intention, the mens rea also mention of intention. If I may be specific, letter A provides, Section 4, letter A, acts intended to cause death or serious bodily injury. And then the mens rea also mentioned to intimidate, which is also another intention. So that intention plus another intention becomes the crime of terrorism. Is that clear, or is it vague?
We agree, Your Honor, but Your Honor, please, may I respectfully give the floor to ASG Rigodon, who is assigned to discuss Section 4 of the ATA, Your Honor.
No problem. Both of you may answer any question that I may propound.
Thank you, Your Honor.
Good afternoon, Your Honor.
Yes, good afternoon, Mr. Solicitor. Assistant ASG, Mr. ASG.
In response to your last question, Your Honor.
Yes.
Our position is that
I'm just echoing what the petitioners are saying. I am just echoing what the petitioners are saying, a crime of intentions.
we respectfully disagree with the position of
course.
Intention alone is not enough. There must be an overt act, Your Honor. And there must and present also must be the purpose for the commission of such overt act, Your Honor.
So that one of the objection of the petitioners that, which I quote, I think that came from Attorney Jokno. He said that an assembly of people, a congregation, a meeting, so long as it is peaceful, can never be a crime. That was he said. Do you agree?
I would agree only, Your Honor, if the uh, intent as mentioned in Section 4 and the purpose as mentioned also in the second paragraph of Section 4 are not present.
In other words, you do not agree that gathering, as long as it is peaceful, is not violative of any crime or criminal, is not considered as a criminal offense.
Based on that scenario alone, Your Honor, and absent any other circumstance, such gathering would not be punishable under Section 4, Your Honor.
But how about the other provisions of the ATA? Section 4, of course, because there is an actus reus, is that correct? Or how about the other provisions? Remember, Mr. ASG, that there are two stages of a crime, preparatory and execution, correct?
Yes, Your Honor.
And these acts of terrorism, or in this law, both the preparatory act and the acts of execution are punishable. Question: will you maintain also that whether it is a preparatory act or an act of execution, there should also be the subjective and the objective element?
Yes, Your Honor.
Yes. So that a mere gathering of people which is peaceful may not be a crime or may be a crime.
Yes, Your Honor. It would depend on the circumstances, Your Honor.
What is the circumstances?
If it can be shown.
What are the circumstances?
It can be shown that the purpose of that gathering is preparatory to the commission of a terrorist act as defined in Section 4, then that gathering can be punished under the provision of the ATA prescribing planning and other preparatory acts, Your Honor.
Why? Would it be a conspiracy? Would it be conspiracy, proposal? All of these are preparatory crimes.
It can be considered as a preparatory crime, Your Honor. If the
Yes,
purpose...
definitely. It is a preparatory crime. It is an inchoate crime.
Yes, Your Honor.
The question is it not, it is violative of the constituent of a crime, subjective and objective elements are or is absent, either of which may be absent.
Since the crimes punished under the ATA are...
My understanding, Mr. Solicitor, Assistant Solicitor, my understanding is, regardless whether it is preparatory or it is an act of execution, there must be the element of actus reus in mens rea, because that is the indispensable element of a corpus delicti. Otherwise, you do not have a crime absent of the two elements.
I fully agree, Your Honor.
Yes. So that we go back for the last time. I will not repeat this again. Gatherings or assembly, as long as it is peaceful, the offender or the members of those people who gathered do not commit a crime. That is according to the petitioner.
Based on the example preferred by the petitioners, what is only evident is the overt act. However,
Mr. ASG, what is an overt act? You mentioned that. So you know what is an overt act because you mentioned it.
that it is the action made by a person, Your Honor.
Action made a person regardless of the intent of the offender, that is an overt act. My understanding of an overt act is that there must be an external act that will cause or manifest the intention of the offender, so that if that act that is committed has no relationship or causative connection with the intent, there is no overt act. Right, Mr. ASG?
Yes, Your Honor.
Yes. So that for purposes of preparatory or executory act, both the elements of act performed and the intent must have a causal connection. Otherwise, there is no overt act. All right, let's go to the next point. You may take note of that, Mr. ASG, kasi it's already 5:18. I just want you to take note that whether it is a preparatory act or whether it is an executory act, they must satisfy the actus reus and the mens rea. As long as the law defines a crime, those are the elements of the corpus delicti. Next point, Mr. SG. What do you understand about a predicate crime?
A predicate crime is a crime that must be established, that must be present in order to establish another crime, Your Honor. An example of this is the definition of terrorism under the Human Security Act, Your Honor.
Is there a predicate crime under the new terrorism law?
None, Your Honor.
None. If a person commits an act intended to cause death, as in fact they have killed a person, what is that crime? Acts intended to cause death, and the accused indeed killed a person. What is that crime?
It can either be homicide or murder.
Can either be homicide or murder. Therefore, if the intent of the offender, as mentioned under Section 4, is to intimidate the general public in the commission of homicide or murder, still there is a predicate crime of murder or homicide, so as to constitute a crime of terrorism. In other words, this law did not completely abandon the element of a predicate crime. All right, next point, Mr. ASG. Last time, the esteemed Justice Karandang asked about this matter of conspiracy under Section 7 and proposal under Section 8. She asked, why is it that under that provision, a person who commits conspiracy will still be prosecuted for the crime of terrorism? If one proposes the commission of terrorism and the crime of terrorism is committed, that offender who made the proposal will be charged for proposal, and at the same time, he will also be charged with terrorism. May I be clarified on this, Mr. ASG?
As stated before, the purpose of the Anti-Terrorism Act in including inchoate offenses is to prevent terrorism at its inception.
Yes, I understand that. I fully understand that. In fact, I even said that in the interpolation of the petitioners. They have to nip the bud so as to secure the state. In fact, I even said that if there is already a tendency, the state may even prosecute that, because it may be too late if they will allow that tendency to be ripened into an offense. My question only is, why? Because under our principle of criminal law, if that preparatory act is executed, that offender becomes liable for the consummated crime. For instance, conspiracy to commit terrorism. And these conspirators indeed commit terrorism. They would be liable for terrorism and not for conspiracy. And that conspiracy will only become a mode for their collective liability. I am strange by this provision because in double jeopardy, if there are crimes which are necessarily included or included in the definition of the crime, there will only constitute one offense. You cannot divide that into several offenses because there is only one offense. Why the provision now that prosecution for the crime of conspiracy is not a bar for prosecution for the acts of terrorism? If I may go further, Mr. ASG, if I may go further, under the old provision, Section 49 for specifically under the old provision, if one is prosecuted for terrorism, that is under the old law, 9372, Republic Act 9372. If you will recall Section 49, if one is prosecuted for terrorism under a valid information, and he pleaded not guilty, there was a trial on the merits, and the case was either dismissed or he was acquitted. Specifically, Section 49 of 9372 provides that that person prosecuted for terrorism can no longer be charged for any of the offenses that are included or necessarily included in the crime of terrorism. So that my next question here now is, if one is prosecuted for terrorism under the new law, may those other crimes be the subject of an independent prosecution like proposal, conspiracy, homicide, murder, etc., which of course are necessarily included in the crime of terrorism.
We submit yes, Your Honor.
All right, I will not argue with that. I will not say you are wrong or you are correct. But I am just wondering why under the old law there is a double jeopardy provision, but here under the new law there is no double jeopardy provision.
Under the HSA, Your Honor, it contains a specific reference to Book 1 of the revised penal code. It says that Book 1 is applicable to the Human Security Act, and I think that the reason for this is that in the definition of the crime of terrorism under the Human Security Act, the crimes punishable under the revised penal code were used as predicate crimes. And under the Anti-Terrorism Act, it removed the predicate crimes and
I see, I see, I
and
see, I
did
see.
not adopt any reference to, did not make any reference to Book 1. Also, it did not adopt that provision that you mentioned, Your Honor, with respect to
I see, I see, I see. So under the old law, it adopted the provisions of Book 1. Under the new law, it did not adopt the provisions of
There's no
Book 1.
reference to Book 1, Your Honor.
It did not adopt.
Yes, Your Honor.
So this new law is totally independent from the provisions of Book 1, which is a general provision of criminal law.
Yes, Your Honor.
But if you will see this new law, there are crimes involving conspiracy. The definition under Section 8, Article 8 of the revised penal code, the provision involving proposal under the same article cannot be used here in the new law.
If applicable, the RPC.
If applicable, therefore,
Your Honor, it is suppletorily applicable.
am I also to understand that since the acts actus reus did not mention a specific crime like homicide, murder, etc., but simply a generic statement of acts intended to cause death or serious bodily injury, that failure to specify the crime will make it a different crime that can be prosecuted independent from terrorism.
No, Your Honor. With respect to Section 4 of the ATA, Your Honor.
All right, I will now give you a very basic example so that the people, the prosecutors, and even the police officer will be clarified. This is a basic example. 3 individuals, X, Y, and Z, attack a police station and killed 3 policemen. They were apprehended. They were charged with terrorism. Why? Because they intended to cause death or serious bodily injury when they fired upon the policeman. Mens rea, that killing caused the intimidation of the general public and undermined public safety. Did you get it right, Mr. ASG?
Yes, Your Honor.
3 individuals attack a police station, killing 3 policemen. They had caused acts intended to cause death, first essential element. And secondly, the mens rea, they had caused the intimidation of the public as well as undermining public safety. Is that terrorism?
Yes, Your Honor. The example falls under the definition of Section 4.
Can it not be a crime of direct assault with homicide so that it may be a lesser offense than that of terrorism? Can it not be a crime of sedition because there is a tumultuous public uprising coupled with that killing of policemen? Or could it be considered as a crime of coup d'etat? Or it may be a crime involving rebellion. I am now confused, Mr. ASG.
If based on your Honor's example,
yes,
elements of the other crime can also be established, then they can be prosecuted for those crimes, Your Honor.
But what will the policeman or the prosecutor do? Will they file a case of direct assault with homicide, or simply sedition and a separate crime of homicide or murder involving the policeman because the intention of the offenders falls under the crime of sedition, or it may be a crime of rebellion because it was done in furtherance of rebellion, in which case it is absurd.
Your Honor, if
under the principle of a political offense, People versus Hernandez, if the purpose is political like rebellion, then the crimes that were committed are considered elements of the crime, and those common crimes like homicide, murder, robbery are all absorbed in the crime of rebellion. Will that be applicable also when there is a terrorism, so that those killings that were committed will also be absorbed by terrorism?
If the killing is a component of the overt act, Your Honor, then it is only the crime of terrorism that is committed if it falls under the...
Very clear, Mr. ASG. If we have to apply the terrorism law, it may be classified as terrorism. Why? Because number one element, acts intended to cause death. Second element, the purpose or intention, intimidation of the general public, seriously undermine the public safety. Of course, that is the necessary consequence when a police station is attacked by several people. It will undermine the public safety. Would that be terrorism?
Yes, Your Honor.
How would you distinguish now a crime of terrorism from an ordinary crime of direct assault?
I think in a direct assault,
homicide, of course.
The purpose mentioned in the second paragraph of Section 4 is not present, Your Honor. It's not required in order to prosecute for direct assault, Your Honor.
But notice, Mr. ASG, the acts that were committed also undermine public safety. If you are living near the police station, you might be at risk. You are totally endangered, and even the passers-by are also endangered, thereby undermining public safety. All right, those are academic, Mr. ASG, but it bogged our mind about these offenses that are similar or akin to the crime of terrorism. Perhaps you can clarify this in your memorandum because of the similar elements of the offense, so that the citizen or even police officers could file the proper offense dependent on the mens rea and the actus reus committed by the accused. Because as I have said, and as the good Solicitor General said, this actus reus and mens rea are the basic foundation of corpus delicti, which must be proven. And since this is a specific intent crime, that specific intent must be alleged and duly proven in the trial. And if I may add, perhaps you can explain this under Section 4. Under Section 4, when the purpose of such act, quote unquote, by its nature and context, is to intimidate the general public. Perhaps you can clarify or expound on this qualification of intimidation of the general public by its nature and context, and we will understand what is terrorism. Political offense doctrine. I think, as I have said, I will not take more than 30 minutes, and I might be cited for contempt if I go further by the not only by the Chief Justice but also my colleagues who are already making to end and conclude this interpellation. Anyway, Mr. ASG, thank you very much. I hope you understand what I was saying. I hope you can explain that in your memorandum so that we will be guided accordingly. Of course, this in the event we proceed with the judicial review. Thank you very much, Mr. ASG, and to all my colleagues, Mr. Chief Justice, thank you very much.
Thank you also, Your
Thank
Honor.
you, Justice Mario. We will adjourn the session after the interpellation of Justice Mario to proceed next Tuesday. Okay. So for lack of material, time being it's already 5:45 by the court's clock. The session is adjourned to resume on May 11, 2021 at 2:30 p.m. Parties are notified in open court. Adjourn the session.
Please remain in your respective seats while the Chief Justice and the Associate Justices leave the virtual session hall.